are eager to appease to investors because you are looking for money. You want your business to scale up. And in that eagerness, you are willing to offer some sensitive information concerning your operations. And you should be very wary of sharing any sensitive information with an investor without a hardcore confidentiality agreement in place. Confidentiality agreements do not protect just the entrepreneur. They are equally protective of the investor because in the negotiation phase, information is shared both ways. A confidentiality agreement prevents the investor from making use of the entrepreneur's information, and it also prevents the entrepreneur from making use of any information the investor would give to the entrepreneur. Apart from that, investors are always willing to engage. Entrepreneurs are always willing to engage investors. Entrepreneurs mostly do not conduct due diligence on investors to ensure that they have sufficient funds to complete the deal that you are requiring. So most investors would use the ploy of investing in your company to learn about your trade operations, and then the next minute you see the investor setting up and doing something similar and taking away your customers. So it is very, very important that you have a confidentiality agreement in place. Additionally, while most of you here have done an amazing job of having a business plan, having your projections online, you could see that a lot of work has gone into it. Most entrepreneurs will go canvassing for investment, and you ask them, okay, so you want this investor to invest in your company. How much is your company worth? Most people do not know. Do you have a business plan? No. How do you expect the investor to give you any money when you yourself have not organized yourself properly to receive the money required? And finally, I would say at the negotiation phase, another agreement most investors will push on entrepreneurs is an exclusivity agreement. You should not be keen to sign an exclusivity agreement unless you are completely sure that the investor is willing to advance the money to you. The reason why an exclusivity agreement should only be signed at the last stage is because when you sign an exclusivity agreement, you cannot engage any other investors. If you do engage any other investors, you are in breach, and then the investor with whom you have an exclusivity agreement can sue you and then get damages for you failing to honor their exclusivity agreement. And then when it comes to negotiation phase, there was one speaker here who had the mobile phone business. Remember, he said he was ready to scale up, but he didn't know at what point in time he needed accountants, he needed HR professionals, he needed all sorts of other finance professionals to assist him in scaling his business. So what I will advise you at the negotiation phase is that do not cut costs. If you cut costs, you would bear it in the long run in the form of you losing your company completely. You need to engage proper professionals. You need to engage a lawyer, a valuer, a tax professional who adequately understand equity financing to assist you in negotiating and drafting the venture capital agreements. So what you should also bear in mind is that in your agreement, there should be provisions that cater for the risks that you would face when the investors come on board. Because the downside of private equity financing is that while you get finance at a low return rate, you are exposed to the possibility of losing control of your business because you would cede shares for the investment that you receive. So in that case, you have to always make sure that you negotiate to ensure the investor's ability to interfere with operations of the company is kept at a bare minimum. To do this, you should always negotiate for very few instances where the investor's consent will be sought in management decisions. In addition, even in cases where the investor consent is necessary, a requirement should be added that the investor should not be allowed to unreasonably withhold his consent, or if the consent is not received within a certain time period, then you should be able to proceed with whatever pertinent decision you need to make. Founders can also negotiate to be paid more in the event the startup performs beyond anticipation. All of you have your returns stated out here. You have an anticipated margin of returns that you have put down. So if you should perform beyond this, means the investor gets more return on their investment. So in negotiation, it will be good for you, the entrepreneur, to have a clause in there that says that if I perform beyond anticipation, then I should have more of the returns you are getting than what you would likely have gotten if I hadn't performed. And apart from that, you should also make sure that there is a strict non-competition clause in your agreement. This benefits both the investor and the entrepreneur. This is because if there is no non-competition clause, the investor can be in the business, and you will see that the entrepreneur would have opened another similar business and would be moving all the customers from that business to the new business because they don't want to give you any returns on your shares. Also, similarly for the founders, you could also have the situation where the investor would, after taking part in your business and being aware of your business operations, will go and open a similar business which will be competing with your business. Also, because most founders are not very rich, in the sense that the startups require more money than what was used to start the business, there are certain instances where the entrepreneur will end up being the minority shareholder. A minority shareholder has very few rights under the law. In addition, there is no fiduciary relationship between the shareholders. When I say that, I mean that there is no requirement that shareholders should act in good faith towards each other. So if the shareholder decides to backstab you, there's no provision in the law that says, oh, you are being a bad shareholder. Why are you doing that to the other shareholder? The only possibility where the law will come in for you is where you are seeking protection from oppressive conduct of the minority, of the majority. And this has been defined in law as very strict, narrow circumstances that will amount to the court intervening in such situations. Accordingly, if you're a minority shareholder and you are an entrepreneur, you should definitely negotiate for consent rights, veto rights, and governance rights. When I say that, I mean any particular decision that will impact on the capital of the company, a major operational decision, should only be taken with your consent. Apart from that, you should also ensure that you have a position on the board of the company, because the board of the company is the entity that has the right to take decisions on behalf of the company. So they can make decisions without your consent if you do not have somebody on the board or you yourself are not a member of the board. You can also negotiate for monitoring rights, but this is rare because most of the time the entrepreneur will be the operational face of the firm. So in all this, what I'll conclude with and say is that negotiation, you always negotiate from a place of strength. But even though you are the one seeking assistance for your business, it is possible for you to get a better deal than what you would get if you engage proper professionals to assist you in negotiating your venture capital agreement. Thank you very much.
Thank you very much. Doc, please, a quick one. Ajamina, the individuals who are pitching are making a plea they want to plead with you if you can make some time to come and give them more of this education, because they are going into the business. They need that legal brain. But remember, legal brain is expensive. You need that legal services. We will charge you. I'll give them the fee. I'll give them the figure. We will charge them. But inshallah, she will come. All right. Thank you very much. A quick one, please. Abinda tafari duka ko wan kasuwanci